Hi guys, Reverend Crystal Cox here. And you can think of this as a parody if you like. You can think of it as educational. You can think of it as your judicial update. Now, I don't usually do this. What I'm going to do today is I'm going to read to you a court ruling. Now, those of you who follow me know that Randazza versus Cox has been going on since November of 2012. Okay, you also know that Mark Randazza sued me, Crystal Cox, and Elliot Bernstein, if I view it, claiming that we had used his good name, we had used his trademark, and we were trying to profit from it, and all sorts of allegations that later turned into extortion. And this has been going on, like I said, since November of 2012. And during that time, Mark Randazza has used the lawsuit to harass me, to get my private records, my phone records, my home address, any trips that I've taken for my church, any wire transfers I've gotten, any church business. He's spoke with my church secretary. He's pried into my private life. He has contacted my exes. He has talked to anybody and everybody associated with me, or Elliot Bernstein if he can, friends, family, you know, like this emails with Stephen Lamont, who used to be involved in I View It, who is no longer a spokesperson for I View It. He has tried to conspire with all of these folks to entrap, to set up me and Elliot for extortion. Mark Randazza has told WIPO that I extorted him. He's told Forbes that I extorted him. He's told NPR that I extorted him. He filed an amicus in the Ninth Circuit that said that I extorted him. He just blathers and lies and commits fraud on the court over and over and over and seems to be above the law. Mark Randazza and lawyers like him, I've learned a lot about all this, but the term copyright trolls, you know, Mark Randazza defended a guy that had, I can't stand saying this, but Glenn Beck raped and murdered a young girl in 1990.com. Mark Randazza represented the guy who bought that. It's pretty disgusting. But then with me, he claimed that I was infringing on his name and had no right, and quoted all these laws that allegedly applied to me having his name in a domain name. And all I had was markrandazza.com at the time. He has accused me of all kinds of false allegations, and he keeps going in order to, I don't know, save face or what. But really, it seems that he should be embarrassed, really. I mean, he's a huge First Amendment, pro-First Amendment attorney, right? He's been on Fox News, he's been in all kinds of media saying that, you know, you gotta like all the speech. You can't just like some of the speech. And what do you do about bad speech? Well, more speech, you know, but not when Crystal Cox come on the scene. See, Mark Randazza basically wanted me to sit down and shut up. He was my attorney for a while, and that didn't work out because, you know, he's a jerk, and he is the kind of attorney that doesn't want to listen to his client, just wants to do what he thinks is best. And you can tell by some of the threads out there in the comment sections that his attorney buddies think that's true too. So they want your money, huge money, like $10,000 a month I think it costs to get Randazza Legal Group involved in your case. And then they want you to shut up because they know best because they're the lawyers. Well, I'm about to read you something that pretty much shows that Mark doesn't know best. But Mark's licensed in, I think, 5 states, right? Randazza Legal Group is in Arizona and Florida and Massachusetts and Nevada. And they allegedly have superior knowledge of the law. So why did they think they could just completely violate my rights and sue me for about $3 million? And in the first month, they got a TRO. So basically the courts gave him all my domain names, gave him my blogs. He redirected them all to one blog post that was about hate about me, that linked to Forbes and Jordan Rushie's blog and Pope Hat and Tracy Conan's fraud files, and, you know, linked to blogs that were accusing me of extortion. All of my intellectual property, all of my top of the search engine ranking from my decade of work and hundreds of thousands of dollars put into my online network, and he just takes it with an unconstitutional TRO. Now, I've put in the courts his own words where he says that it is unconstitutional. to have a TRO. So basically, before it was even adjudicated for the First Amendment, he just seized all the names, right? They have no value to me now. It's been a year and a half, 2 years, they're not in the search engines anymore. He's had control of them illegally, unconstitutionally. And it's been a very long time, and he's used this lawsuit to harass me, to cause massive stress in my life. He files things constantly. I keep, I have to keep on guard all the time. It's been nearly 2 years. He was my attorney, but yet he conspired with Tonkintorp in the Obsidian versus Cox case. He filed an amicus brief against me in the 9th after I won, telling them I extorted him. And all this is based on lies and fraud on the courts and hearsay. The Ninth Circuit had said, they threw in a pot shot that I was basically an extortionist. And that's because Mark Randazza and David Amen, these attorneys, have convinced Forbes, New York Times, NPR that I'm an extortionist, so they've ran these articles. So apparently judges used this as adjudicated fact. Judge Hernandez did this, and so did the Ninth Circuit. And then they just put it in a ruling and say, there it is. Well, this ruling today that I'm going to read to you really makes a good case for the opposite of that. Now, in the beginning, so let's say about a year and a half ago, Mark Randazza filed the lawsuit. He didn't bother serving me. He basically just had his media friends start trashing me, right? So I wanted to get in there and I wanted to expose him for what he was doing, for what he does to suppress speech and whistleblowers, and so I served myself via email. Even though I've sued Mark Randazza and he will not accept via email. He doesn't play fair, that's for sure. He is hypocritical and he's not very bright. Anyway, they filed the complaint right after that, before they even served me. They're filing all this stuff, and part of that was a summary judgment. They filed the TRO, just a whole bunch of stuff really at once. Now the summary judgment was basically, they're saying I can't win, and so they want the courts to just award it to him. And this was quite a long time ago, the summary judgment. I don't remember the exact date, but you'll see the docket, docket number 75, I think 79. So it was a long time ago because we're at docket number like 200 now. All right, are you guys ready? So basically, this is a ruling, April 10th, 2004, and it is an order that is denying the motion for the summary judgment. Now, I had filed the motion for a summary judgment at that time too, and mine was denied too, but my counter complaint was denied, so they kind of went together, so it was ruled as moot. Anyway, pay attention to this because I don't have a copy yet because I can't afford to be on Pacer, and I got this in the mail. And if you've been sued by these attorneys and anything similar to the Randazza versus Cox case at all, these are some really good things to know. No one else is really doing it. Like I said, WIPO used hearsay. Forbes seems to be able to do whatever they want. New York Times does whatever they want. The Ninth Circuit uses hearsay. And just throw it in a ruling, and then they make your life hell, and they defame you and slander you. This is wrong. This is unconstitutional. This is illegal. This is immoral. Judge Hernandez did it to me. The Ninth Circuit judges did it to me. But this makes a good case for, that's not right. Hearsay is not adjudicated fact. All right, so it's an order denying a motion for summary judgment. It's document 200 in Randazza versus Cox, which is a case out of Nevada. And the judge is Jennifer Dorsey. And, okay. Well, let's get started. This cyber squatting case arises out of the alleged targeting of plaintiff Mark Randazza, his wife Jennifer, and their young daughter Natalia, by defendant Crystal Cox, a self-proclaimed investigative blogger. The Randazzas allege that Cox and defendant Elliot Bernstein have engaged in an online harassment campaign to extort them by registering dozens of internet domain names that incorporate the Randazzas' names and then demanding they agree to purchase Cox's reputation management services to remove this allegedly defamatory material from the internet and rehabilitate their cyber reputation. Cox maintains that this lawsuit was instituted to harass her and stifle her First Amendment freedom of speech and expression. The Randazza plaintiffs moved for summary judgment on their claims against Cox. But as one of those claims is legally untenable and genuine issues of material fact preclude summary judgment on the remainder, their motion is denied. Cox has pending her own motion for summary judgment on her original countercomplaint, which has since been stricken, so that motion is also denied. Okay, motion for summary judgment. In November 2012, the Randazza sued Cox and Bernstein, alleging violations of individual cyber privacy protection for various registered websites under 15 U.S.C. 8131. Cyber squatting for various registered websites under 15 U.S.C. 1125d. Their right of publicity under NRS 597.810. Their common law right of publicity, intrusion upon seclusion, and civil conspiracy. The claims were based on allegations that Cox and Bernstein registered several domain names containing plaintiffs' names, that Cox's blog posts contained objectionable characterization of the plaintiffs, and that these acts were designed to extort and harass the Randazzas and capitalize on and damage the goodwill Mark Randazza claims he built up in his name as a prominent First Amendment attorney. Sorry, I'm laughing, but his name wasn't good. I mean, the stuff that I posted to expose him because of what he did to me, other people were saying it. He doesn't have a good reputation. And yeah, a prominent First Amendment attorney. Taking away someone's First Amendment rights, just unconstitutionally, bam, done. Yep, this is my thing. It's over. Take her names, you know. GoDaddy didn't even lock the servers, and they're sent to Mark and redirected to something defaming and slandering me, which has caused me irreparable damage. Right? Come on. Bernstein has not appeared or answered the allegations, but Cox has. She contends that she registered the domain names to control public relation information when she thought Mark Randazza would represent her in another lawsuit. Cox also strongly objects to plaintiff's characterization of her motivation and actions as extortion. I object! I object to the allegation of extortion! The tortured history of this case is rife with procedural maneuvering from both sides. All parties have disrupted the court's timely management of its docket, wasteful judicial resources, and threatened the orderly administration of justice by sandbagging the docket with multiple impertinent, legally unsupportive, and frivolous filings. Well, I try, right? I'm not a liar. I'm a creative writer. The instant motions were not spared from these tactics. Despite Mr. Randazza's self-proclaimed prominence as a First Amendment attorney and being represented by independent counsel, plaintiffs have failed to authenticate more than half of their pro-offered exhibits in support of their motion. And half of the authenticated ones are immaterial to this motion. Equally confounding is that pro se Cox has submitted a 255-page summary judgment motion and a 183-page opposition to plaintiff's summary judgment motion, neither of which contained relevant legal authority. Well, you know, the court won't give me an attorney. I do the best I can. All right, authentication of evidence. The first step in analyzing these motions is to determine what evidence the court may consider in evaluating whether the parties met their respective burdens. In Orr v. Bank of America, the Ninth Circuit Court of Appeals made it clear that unauthenticated documents cannot be considered in a motion for summary judgment. To authenticate a document, the proponent must offer evidence sufficient to support a finding that the matter in question is what its proponent claims. As the summary judgment procedure is the pretrial functional equivalent of a directed verdict motion, it requires consideration of the same caliber of evidence that would be admitted at trial. Thus, it is sufficient for a litigant to merely attach a document. No, it is insufficient for a litigant to merely attach a document to a summary judgment motion or opposition without affirmatively demonstrating its authenticity. Documents may be authenticated two ways. Okay, now pay attention, folks, because when you're submitting different documentations as evidence, you have to authenticate them. Okay, so pay attention on the ways that you authenticate documents that you're submitting as evidence to the court. Documents may be authenticated two ways. One, through the personal knowledge of a party who attests that the document is what it purports to be, or any other manner permitted by Federal Rules of Evidence 901B, which provides 10 methods of authentication, or 902, identifying self-authenticating documents that require no extrinsic evidence of authenticity in order to be admitted. Documents authenticated through personal knowledge must be attached to an affidavit signed by a person with personal knowledge about the document, such as the drafter or signer of the document or the custodian of the document, kept in the ordinary course of a business, depending on the type of document and its particular relevance, or properly authenticated deposition testimony in which the same information was elicited. Plaintiff's pro-offered evidence falls into several categories, and the court addresses each in turn. So keep in mind that attorneys like Mark Randazza can simply, and he's the plaintiff in this case, right? So he just swears to a whole bunch of stuff being true, and he signs it as a declaration or whatever, and he lies. He commits fraud on the court. He's believed because it's authenticated, because he is a party who knew. He's a party who knew, but he lied. Okay? In Randazza versus Cox, Mark Randazza has committed fraud on the courts over and over and over, and apparently, so far, he seems to be above the law and all that. So, all you victims of Mark Randazza, good luck. All right. You say that last one again. Plaintiff's pro-offered evidence falls into several categories, and the court addresses each in turn. Periodicals. Plaintiffs offer at Exhibit B an article from Forbes magazine. Printed material purporting to be a newspaper or periodical is self-authenticating. Okay, so it's a Forbes article, so it's pretending to be a Forbes article. It is a Forbes article. So that's authentic, right? Thus, this article is self-authenticating. Its contents, however, are hearsay, not subject to any exception. Accordingly, the periodical is not admissible for summary judgment purposes. Okay, so now if you know about my case, you know that the New York Times article of hearsay and defamation and slander was used by 3 Ninth Circuit judges against me, Crystal Cox, to accuse me of extortion in a Ninth Circuit appeal case where I won. They just threw it in as a pot shot to ruin my life. Now anybody that Googles me, that sees all of this bad stuff about there, that I'm an extortionist because these attorneys and Forbes, NPR, and the New York Times, which would be Forbes, Kashmir Hill, the New York Times, David Carr, and then NPR, Bob Garfield, and you got WIPO, they have all claimed that I'm an extortionist, and based on hearsay. No adjudicated evidence, no adjudicated facts. And whether you think I'm an extortionist or not is irrelevant. This could happen to any one of you folks, okay? So this judge is basically saying, look, it's not admissible, it's hearsay. Okay, but in the court of opinion, it is admissible. And these judges are issuing their opinions not based on law. Like, they just threw in this opinion, well, you know, apparently she has a history of committing extortion. They define extortion. Judge Hernandez accused me of extortion in a denial of a new trial. Okay? Now, for judges to do this against someone who's an investigative blogger, someone who's exposing corrupt judges, exposing corrupt attorneys, corrupt CEOs, they're basically trying to silence you, suppress your free speech, they're trying to shut down the real news, and they are shutting these people up. People got kids, they got regular jobs, they've been put in mental institutes. There's a lot of ways that they shut people up that they weren't able to do to me. I just kept going. So I know a lot of you folks have an opinion of me that's bad, but look at the details of all of my cases and know that this could happen to you, okay? The idea, the stand that I made for the Ninth Circuit was to level the playing field, to end the monopoly of free speech that big media has. Now you have equal rights as all journalists in big media. Okay? You have equal rights to them to report the news on public matters. You can break the news on public things that are public matter. And they can come back and they can call you every name in the book, and they can accuse you of crime, they can accuse you of murder and robbery and whatever. Okay. And you can sue that paper for defamation. I mean, I tried to sue Forbes and the New York Times. It didn't work. Reuters just left out the word apparently and accused me of extortion. If anybody wants to represent me, email me, crystal@crystalcox.com. I have a very good case, but just didn't work out. Okay, so they they can't be used as adjudicated fact, but the judges use it. They read the New York Times. They're like, hey, she's an extortionist. Or like Judge Hernandez, they just listen to David Amon and Mark Randazza and just what's going around, and it's just hearsay. Or they'll read a blog or read a newspaper, and they'll just say, well, if it's coming from that source, Forbes, the New York Times, NPR, must be right. She must be a criminal. I mean, Kashmir Hill even said flat out, the Forbes journalist, that I was under investigation by the Oregon Attorney General. I did a Freedom of Information to the Oregon Attorney General. I didn't even have a consumer complaint. There was no investigation. She lied. I have a very good lawsuit against Forbes. I need an attorney to represent me. I have filed lawsuits against them myself, and they've just been dismissed. Anyway, so that is very important. Thus, the article is self-authenticating. Its contents, however, are hearsay, not subject to any exception. Accordingly, the periodical is not admissible for summary judgment purposes. It's not admissible for rulings by judges either. It's not admissible by Ninth Circuit rulings in a civil case that has nothing to do with extortion. Okay? Websites. Few courts have considered how a website printout or blog posting may be authenticated. Those that have considered the issue have found website printouts sufficiently authenticated where the proponent declared that they were true and correct copies of pages on the internet, and the printouts included their web page URL address and the dates printed. On this last page it says Federal Rule Evidence 902. Listing domestic public documents that are sealed and signed and certified. Foreign public documents, certified copies of public records, official publication newspapers and periodicals, trade inscriptions. Okay, anyway, research this Evidence 902. The point is you have to authenticate the evidence that you're submitting. You can't just say, oh, here this is, and like I made it up. Okay, you have to authenticate where it came from and how you got it. And then it also talks about C.or. 285 F3D at 773-74 about document authentication. The websites contained in exhibits have been properly authenticated under this standard because Plaintiff Mark Randazza has attested that they are true and correct copies, and the printouts include the web page URL address and the dates the websites were printed. However, plaintiffs have not authenticated any of the purported website contents in exhibits D, G, M, O, and P, although Mr. Randazza has attested that these exhibits are true and correct copies, and the printouts include the web page URL. Absent are the dates the web pages were printed. Without the print dates, these website printouts have not been properly authenticated and the court will not consider them. So make sure you have your print date on them. Okay, letters, emails, and text messages. A document may be authenticated by personal knowledge, by a witness who wrote it, signed it, used it, or saw others do it. Okay, so if anyone sees you do something, then you need to have a sworn affidavit from them that this happened. So you can't just tell the courts that it happened, and you can't just submit a document that proves something without it being authenticated of where the document came from. So again, I'm going to read that again. A document may be authenticated by personal knowledge, by a witness who wrote it, signed it, used it, or saw others do so. Although circumstantial evidence, like an email context, email address, or previous correspondence between the parties may help to authenticate an email, the most direct method of authentication is a statement from its author or an individual who saw the author compose and send the email. Now, if you remember right, in the Obsidian versus Cox case, they used an email to ruin my life. They used an email in the closing statements of my case to make the jury hate me. Okay? They used an unauthenticated email that was not supposed to be evidence that I objected to, that I asked. You can see in the trial transcripts the day before the trial, I think it's on page 15, where I told the judge I was being accused of extortion, and the judge said, no, you're not. Okay? They used this email in the Seattle Weekly, in the New York Times. They used it in the denial of a new trial. Obsidian, you can hear the hearing in the Ninth Circuit. They accused me of extortion in that, and it's all based on this one email that is circumstantial evidence that nobody really had to prove that I even sent it, and it was one of 5 emails in a settlement negotiation after I had been sued for $10 million. All this happened. Now, this can happen to you, folks. I know many of you have just read your favorite blogger on this, or the New York Times or Forbes, but look into the details of how far they go to silence whistleblowers, to silence investigative bloggers. Okay? Yeah, this is a great win. The playing field is leveled, but at the discrediting of the person who's writing it, accusing them of a criminal and effectively, all the media and all the courts thinking that I'm guilty of extortion, you know, you folks need to dig deeper. If you're out there and you're an investigative blogger and you're exposing corruption, you need to understand that those of you who say you're not like me, well, you are like me, okay? I never extorted anyone, okay? It just didn't happen. It's all lies. It's all judges and big media and small media and lawyers setting me up to make it look like what I have to say and exposing their corruption isn't valid when it is. All right, plaintiffs have authenticated the letter sent from Mr. Randazza to Defendant Bernstein, presented in Exhibit A, by Randazza's affidavit stating that he wrote and signed the letter. Similarly, Mr. Randazza's curriculum vitae in the About page of his blog attached at Exhibit 1 I and J have been properly authenticated because Mr. Randazza is a person with personal knowledge and he wrote his curriculum vitae and the About page of his own blog. Plaintiffs have also authenticated via circumstantial evidence the emails between Cox and Mr. Randazza contained in Exhibit H. Because the email contains insufficient indicia of authenticity by context, the email addresses and previous correspondences between the parties. But plaintiffs have not authenticated the purported emails between Cox and Dillon Energy CEO Martin Kane contained in Exhibit C. Now, you guys have watched my other videos. You know that Martin Kane was a man who lied to the Montana Department of Labor, and he got with Randazza, and they tried to set me up for extortion. He was a real estate buyer from another agent, and he had contacted me to do marketing for him and to help him because he was trying to get a patent through. And because I wanted him to bring the jobs to my town, which was Eureka, Montana at the time, I was trying to help him find a property. So I found the seller. I was working with the seller, not him as the buyer. He had his own buyer's agent. And the seller ended up turning on me, and the commissioners, the senators, the authorities in the state, because I was exposing corruption on all of them, told Dillon Energy that they would not work with them. Hi guys, I'm not sure where this shut off. So I can't tell by the front of the camera where this shut off. So I am going to, this is part 2 of Randazza versus Cox and the denial of a summary judgment. And it says that plaintiffs have not authenticated the purported emails between Cox and Dillon Energy CEO Martin Kane. Although plaintiffs attempted to authenticate Exhibit C, circumstantial evidence, there's a gap in the email chain. MJR at Randazza.com purportedly received the forward email from Matt.Bear at DillonEnergy.com, SavvyBroker at Yahoo.com, the email associated with Cox, sent to Dillon, CHP, MC at Verizon.net. Therefore, it is unclear how the person in control of the email address, Matt.Bear at DillonEnergy.com, came to be in possession of an email originally addressed to Dillon, CHP, MC at Verizon.net. Without some explanation of the gap in this email chain by someone with personal knowledge, there is insufficient circumstantial indicia of authenticity for the court to use this document. So I'm not sure where this shut off, so if I'm repeating this, then please forgive me, but this is important stuff. So basically, yeah, I know Mark will probably use my legal advice here, because, he apparently don't know this stuff, but if you folks have this situation, what you want to do is you would get like this Matt Bear person. He would have had to sign something and swear to it that how he got this email. So that would authenticate it, right? So say Martin Kane's the CEO of the company. He gave it to him because he was, wanting to entrap Crystal Cox and set her up for extortion, and then he could swear to that. Obviously, I'm being, because they're not going to admit their guilt. So basically, the idea is for you can't just submit an email to the court without authenticating it, even though that's what they've done to me. Forbes, the New York Times, all the courts across the land. This judge is saying that that is not proper. All right, so, yes, and it is unclear. How did this person get in control of the email? I mean, somebody just forwards an email and all these unrelated things, and Mark Randazza should know this stuff. All right, plaintiffs have not authenticated the text message screenshot in Exhibit A either. The screenshot purporting to be a text message exchange between Messrs. Randazza and Bernstein has not been authenticated because it does not have circumstantial indicia of authenticity. It is unclear which phone numbers sent or received the message, or to whom those phone numbers belonged when the screenshot was taken, or who took the screenshot. Without this type of supporting evidence, the court cannot consider the text message. So you guys have to authenticate your phone numbers, okay, best you can. So say, you know, whatever information you get from the courts, probably why Mark was trying to get more of my phone records, you have to prove that that person owned that phone at that time. Okay, so otherwise it's just circumstantial evidence. Finally, Exhibit L, which is compiled listings made by the plaintiffs of the allegedly infringing domain names, is not evidence, and no realistic effort has been made to render it authentic and worthy of evidentiary consideration. Administrative agency decisions. Okay. Certified copies of public records are self-authenticating when the copy is certified as correct by the custodian or another person authorized to make the certification. The WIPO administrative decision contained in Exhibit F has not been properly authenticated. Although Mr. Randazza attests that it is true and correct copy of the WIPO administrative panel decision, he lacks personal knowledge of the authenticity of this document because he did not write it, sign it, use it, or see others do it. It has not been established as a self-authenticating document because it is not accompanied by a certification completed by the custodian or another person authorized to make the certification under WIPO policy. So basically, folks, you need to have someone, so he should have had Peter L. Michelson sign a certification that he truly and correctly wrote this, it was a WIPO decision, or somebody at WIPO that this was an official copy. So this is very good information for you to know. This judge is taking things seriously. Whereas like Judge Marco Hernandez, he just was all willy-nilly with it. The Ninth Circuit was willy-nilly with it, accusing me of a crime in a civil case without giving me due process. Okay? You cannot just put in evidence and tell the court that someone's guilty and the court decides they're guilty unless you know the judge or you control the judge, which rumor has it that Mark Randazza does control many judges. Clearly, he does not control this one. She's sassing us both. Okay. Oh, in my opinion. And it says, finally, regardless of whether the document is authenticated and admissible, the WIPO decision is not entitled to deference. All right, well, there you go. Okay, now he submitted a YouTube video as some sort of evidence that I was bad and improper, and I don't even remember what, I have so many videos online, I don't even remember what I said, but he took some part of the video out and said that I did something bad, and I don't even remember what it was. This is so long ago. Okay, Exhibit N is a transcript of a YouTube video. The single court, having addressed how to authenticate a YouTube video, albeit in a criminal context, found that videos from the online video network are self-authenticating as a certified domestic record of a regular conducted activity if their proponent satisfies the requirements of the business records hearsay exception. So, folks, be careful what you say on YouTube because it can and will be used against you, but only if they authenticate it. Okay? To meet this exception, the evidence must be accompanied by a certification of their custodian or other qualified person that satisfies three requirements. A, that the records were made at or near the time by or from information transmuted by someone with knowledge. That they were kept in the course of a regular conducted activity of business, and that making the record was a regular practice of that activity. The transcript of the YouTube video contained in Exhibit N has not been properly authenticated. Although Mr. Randazza has attested it is true and correct, because he loves to do that, you know, which I call fraud on the court and perjury, but that's just in my opinion, of a transcript of a video posted on YouTube.com. He has not established that he is a person with knowledge who prepared the transcript, nor has he established when it was prepared and that it is complete and accurate. To the extent that the YouTube.com video itself is offered as evidence, it similarly has not been authenticated because plaintiffs have not pro-offered the certification of YouTube's custodian or other qualified person verifying that the page had been maintained as a business record in the course of regularly conducted business activities, Without this certification, the video has not been properly authenticated and cannot be considered. With this evidentiary limitations, the court now turns the merits of plaintiff's summary judgment. Okay, make sure this is still recording because it shut off on me earlier. Plaintiffs are not entitled to summary judgment on their claims. Summary judgment is appropriate when the pleadings, depositions, answers to the interrogations, I call them interrogations, interrogatories, they're interrogations to me, and admissions on file, together with the affidavits, if any, show there is no genuine issue as to any material fact, and that the movement is entitled to judgment as a matter of law. When evaluating the propriety of summary judgment, the court views all facts and draws all inference in the light most favorable to the non-moving party. If reasonable minds could differ on the material facts at issue, summary judgment is not appropriate because the purpose of summary judgment is to avoid unnecessary trials when the facts are undisputed. You know, like the facts are undisputed that Mark Randazza no longer has a case. The facts are undisputed that he has harmed me deliberately. How could he not know all of this stuff? And he's been using it to harass me for nearly 2 years. Okay, so that it cannot be disputed that Mark Randazza has done this to me. So it seems to me like he no longer has a case. He never had a case in the first place. He filed a SLAPP lawsuit against me, then helped make Nevada's SLAPP laws stronger. And so it seems to me that my counterclaims are very legit and that he has no leg to stand on and he had no right to sue me. He just has been harassing me. And this could happen to you, folks. These attorneys, like Mark Randazza, do this all the time. Okay, if reasonable minds could differ on the material facts at issue, summary judgment is not appropriate because the purpose of summary judgment is to avoid unnecessary trials when the facts are undisputed, and credibility determines the weighing of the evidence and the drawing of legitimate inference from the facts are jury functions, not those of a judge. Okay. Once the moving party satisfies Rule 56 by demonstrating the absence of any genuine issue of material fact, the burden shifts to the party resisting summary judgment to set forth specific facts showing that there is a genuine issue for trial. The non-moving party must do more than simply show that there is some metaphysical doubt as to the material facts. He must produce specific evidence through affidavits or admissible discovery material to show that there is a sufficient evidentiary basis on which a reasonable fact finder could find in his favor. Genuine, number one here, it's kind of indented and bolded. Genuine issues of material fact preclude summary judgment on plaintiff's claims 1 through 3 relating to violations of individual cyber piracy protection under 15 U.S.C. 8131. The Randazza's first, second, and third claims arising under 15 U.S.C. 8131 alleges that defendants' registration of the multiple domain names violates the provision that provides cyber piracy protection for individuals. In pertinent part, Section 8131 provides that any person who registers a domain name that consists of the name of another living person or a name substantially and confusingly similar thereto, without that person's consent, with the specific intent to profit from such name by selling the domain name for financial gain to that person or any third party shall be liable in a civil action by that person. Or, you know, like the Glenn Beck name, you know, your attorney makes money, right? Like Mark Randazza made money on the case. The guy got to keep the domain name. You know, Mark Randazza is a hypocrite over and over and over. And did that guy register the name to profit? Did they have to prove that? Or did they just back off? I mean, read all the documents of all these cases, folks. Good stuff. To prevail under this theory, a plaintiff must show that the specific intent to profit existed at the time of the registration. The statute further provides a very limited exception for good faith registrants. A person who in good faith registers a domain name consisting of the name of another living person or a name substantially and confusingly similar, thereto shall not be liable under this paragraph if such name is used in, affiliated with, or related to a work of authorship protected under Title 17, including a work made for hire as defined in Section 101 of Title 17. And if the person registering the domain name is the copyright owner or licensee of the work, the person intends to sell the domain name in conjunction with the lawful exploitation of the work, and such registration is not prohibited by a contract between the registrant and the named person. The exception under this subparagraph shall apply only to a civil action brought under paragraph 1 and shall in no manner limit the protections afforded under the Trademark Act of 1946, 15 U.S.C. 1051, or other provisions of federal and state law. Genuine issues of material fact preclude entry of judgment in the Randazza's favor on these first 3 cyber piracy claims. They have failed to show by admissible evidence that at the time the defendant registered domain names, there was a specific intent to profit by selling the domain names to plaintiff or a third party. At best, they have demonstrated only that Defendant Cox offered to sell Mr. Randazza a few of the domain names at some point after the domain name was registered. But that's not true. Mark Randazza ordered me to give him the names, said he'd give me $10-20 for my trouble, but I never ever offered to sell him the names. And when I put markrandazza.me here, kitty kitty, that was a joke. And that wasn't sent to Mark Randazza, that was sent to the world. So at any rate, I'll read that again. It says, at best, they have demonstrated only that Defendant Cox offered to sell Mr. Randazza a few of the names at some point after the domains were registered. This ex post action does not prove the specific intent to profit at the time the domains were purchased. Even if the court were to consider post-registration conduct, it still cannot infer intent at the time of registration because the evidence undermines that conclusion. The Randazza's own evidence suggests that Cox bought one domain name to control the search and PR on her case, if Mr. Randazza represented her. This tends to show that Cox did not have a specific intent to profit at the time of the registration, creating a genuine dispute and precluding summary judgment on these claims. Number 2, genuine issues of material fact preclude summary judgment on claims 4 to 5 for cybersquatting under 15 U.S.C. 1125. The Randazza's 4th and 5th claims allege that defendant's registration of the domain name violates the provisions that prohibits cybersquatting. To prevail on a cybersquatting claim, a plaintiff must show that the defendant registered, trafficked in, or used the domain name is identically or confusingly similar to a protected mark owned by the plaintiff, and that the defendant acted with bad faith, intent to profit from that mark. Plaintiff have failed to show by admissible evidence essential elements of these cybersquatting claims, precluding entry of judgment in their favor. Jennifer and Natalia Randazza's claims fail as a matter of law because they have not alleged or shown any fact to support common law trademarks in their personal names. So why did Mark Randazza is a trademark and intellectual property expert. He's a First Amendment expert. Why did he do this to his wife and child? Why did he drag them into this? Okay, I didn't. Mark did. Put a picture in Forbes? Yeah, I registered the domain name. As a joke, as a poking fun at Mark. I didn't write anything on it, and I didn't even tell anybody. I hadn't even made it public. How did he know? See, he had a GoDaddy insider that told him I had the domain name. Okay? He violated my rights of privacy, seen that I had that domain name, and then he claims that I had a blog attacking his daughter and they have trademark violations and blah, blah, blah. Goes on NPR, and NPR is all dramatic. And what did you do in your darkest hour? Have you seen that interview? I mean, it's just, it's horrific. It's like this parody spoof movie. And these are real media, folks. This is NPR. This is Forbes. This is the New York Times. This is, you know, WIPO. And you got Mark Randazza filing amicuses to the 9th, and all these people just, why are they believing him? Why are they over and over accusing me of extortion? I mean, seriously, if you think I've extorted you, call the FBI. Okay? Mark Randazza is an attorney. These judges, the Ninth Circuit judges, aren't they supposed to protect you guys? I mean, why are these judges and all these attorneys just putting this in newspaper articles and in rulings and just using it just to ruin me and defame me and slander me because I'm exposing corruption and they want to discredit me and try to teach me a lesson? If I'm an extortionist and guilty of the felony crime of extortion, then why didn't they file criminal charges? Okay, why are they filing civil charges to get millions of dollars out of someone who doesn't have a dime? Yeah, so there's that. Okay. Goes on to say, okay, I won't read that one again. But anyway, they're not entitled to summary judgment because they didn't have a trademark. Why he brought him in is ridiculous. This is going to affect his daughter's life for the rest of her life. This is a record now. She was 3. Sick. Assuming Mr. Randazza could show a common law trademark in his name, he has not demonstrated defendants acted with bad faith intent to profit from that mark. To determine whether defendants acted in bad faith, the court considered the 9 non-exclusive factors outlined in 1125D1B. Number 1, the trademark or intellectual property rights of the defendants in the domain name. Number 2, the extent to which the domain name is the legal name of a person. Number 3, defendants' prior use of the domain name in connection with a bona fide offering of goods and services. Number 4, whether the defendant made a bona fide non-commercial fair use of the domain name. Number 5, defendant's intent to divert consumers from the mark owner's online location to a site accessible under the domain name that could harm the goodwill represented by the mark, either for commercial gain or with the intent to tarnish or disparage the mark, by creating a likelihood of confusion as to the source, sponsorship, affiliation, or endorsement of the site. You guys know there was no confusion. I came right out and I called him all sorts of names and I said I was his enemy and I called war and I put out my war cry, and I certainly was not trying to divert his good name and his traffic to my blog so that I could sell what? Sell my anti-corruption exposing who I thought was a dirty, corrupt, asshole, hypocritical attorney who had violated my constitutional rights and was interfering in my $10 million lawsuit where he was my attorney? Do I not have any rights? I'm the one that has the good case here against all of them. Again, my email, crystal@crystalcox.com if you want to represent me to sue any of these parties. I am the injured party. Number 6. Whether the defendant offered to transfer, sell, or otherwise assign the domain name to the mark owner of any third party for financial gain without having used or having an intent to use the domain name. So, if you've used the domain name for something else and then you sell it, I mean, it's my intellectual property. You know, he's trying to claim that I bought it just to extort him and then that's all it was ever for. No, the domain names were always to expose corruption and to and hopes that Mark Randazza cannot ever do what he did to me to anyone else. And even if I die tomorrow, I think that whoever Mark Randazza makes his victim again will have a lot more knowledge. And attorneys like him, when they read the Randazza versus Cox docket, the victims, even the pro se people, will have a pretty good place to go when this happens to them. Okay, so even if Mark's buddies follow through on their threats, and if I die tomorrow, this is still out there, and you folks know how to defend yourself against these asshole, hypocritical, above-the-law attorneys. Okay, number 7. Whether the defendant provided false contact information when registering the domain name. Whether the defendant registered multiple domain names which defendant knew were identical to or confusingly similar to marks of others that are distinctive at the time of registration of such domain names. Number 9. To the extent to which the trademark incorporated into the domain name is distinctive. I don't think you could confuse a domain name markrandazzaisanaasshole.com or markrandazza.sucks.com or randazza.legalgroups.sucks.com. No, I think it's markrandazzaislyingasshole.com. I don't think you could confuse these with his official I'm selling First Amendment rights attorney stuff. Right, services or whatever. Yeah. Mr. Randazza has not shown by admissible evidence that the non-exhaustive factors balance in his favor. Although some factors may balance in his favor, such as 1 through 3, others arguably do not, such as 4 through 7. As plaintiffs have failed to prove an essential element of these claims, summary judgment is denied. Gee darn. Sorry about that. Okay, number 3. Genuine issues of material fact preclude summary judgment on Claim 6 for right of publicity under NRS 597.810. Plaintiff's sixth claim alleges that defendants' registration of the domain names containing the entirety or part of the Randazza's personal names violated their rights of publicity under Nevada law. NRS 597.810 prohibits any commercial use of the name, voice, signature, photograph, or likeliness of another by a person, firm, or corporation without first having obtained written consent for use. The statute defines commercial use as the use of the name, voice, signature, photograph, or likeliness of a person on or in any product, merchandise, or goods, or for the purposes of advertising, selling, or soliciting the purchase of any product, merchandise, goods, or services. Genuine issues of material fact also preclude entry of judgment in plaintiff's favor on this privacy claim. The Randazzas have failed to show by admissible evidence that defendants intended to advertise, sell, or solicit the purchase of any product, merchandise, goods, or services. Indeed, plaintiffs have offered no admissible evidence that tends to show any commercial use of their names. Thus, summary judgment is also denied. Let me read that again. Plaintiffs have offered no admissible evidence that tends to show any commercial use of their names. They knew this. So why did they get to sue, harass, bully, depose people? They threatened to sue people that I've known, people that I've worked with. They've got my invoices from people who I've worked with. They've gotten wires. They've gotten my house address from my church. They've harassed people in my life. They've got my phone records. They've violated the rights of those I provide spiritual counsel to. They've tried to depose my exes. They've emailed people and just threatened to sue them if they don't give them what they want. All of this knowing full well as a cyber squatter expert, a trademark expert, a domain name expert, which is all on his letterheads from the past, and a First Amendment proponent, allegedly. And he does all of this opposite to me relentlessly for 2 years and has not let up. Liar, liar, pants on fire. All right. Number 3. No, we already read number 3. Okay. Number 4. Claim 7 for common law right of publicity is legally untenable. I like to do. All right. Plaintiff's 7th claim alleges that defendant's registration of the domain names containing the entirety or part of the Randazza's personal name violated their common law rights of publicity. Nevada has codified the right of publicity tort. Because the statute provides a complete and exclusive remedy for right of publicity torts, Nevada law, which certainly Randazza Legal Group should know, you know, that's the attorneys for Mark Randazza. There's no conflict of interest there, of course. Nevada law does not recognize a common law right of publicity. Oh, snap. Forgot to look that up. As Nevada law does not recognize this cause of action, plaintiffs have failed to state a viable claim under this legal theory, and this claim is dismissed with prejudice. Ha! Sorry. I thought that was a good one. Number 5. Genuine issues of material fact preclude summary judgment on Claim 8 for common law intrusion upon seclusion. Intrusion upon seclusion. The Randazza's 8th claim alleges that defendants' registration of 5 of the domain names containing the entirety or... Hi guys, Reverend Crystal Cox here. This is part 3. The video shut off and who knows where. I kind of have an idea, but So, here's the deal. It shut off in the part that cracks me up, which is Mark Randazza thinking that he has a right to solitude and seclusion. Okay, but I don't have that right. He puts my home address on the docket. His buddies text me they're coming to my town. I get threats constantly. I'm under constant duress. He has violated my rights to privacy. He defended Kate Gosselin, right? And she has a right to privacy in her emails, but I don't. He gets my emails. He gets information from my church. He gets information from my friends, my family. He bullies people. He threatens people. He's just relentless. And then because I bought a domain name, I have violated I have intruded on his rights to seclusion, intrusion of seclusion. Really? He interfered with my $10 million case. He advised the plaintiff in that case to steal my right to appeal through a sheriff's sale. When I had a $2.5 million judgment, which has since been overturned. I still have to face that $10 million lawsuit in the lower court. He has made me publicly look like a criminal and extortionist, which has prejudiced me in my lower court proceeding when I go back to be pro se, representing myself in Obsidian versus Cox. He has threatened my sources. He has sued my sources. He's put makes in my car and wished death on my sources. He's just been relentlessly attacking me. He has caused irreparable harm on my health, on my life, my relationships, my relationship with those I spiritually counsel. Just massive, massive damage relentlessly since November of 2012. Well, actually, that was when he filed this lawsuit. He actually started harassing me right around about, let's see, December of 2011, he was acting as my attorney. So that next January 2012, he's been harassing me and attempting to sabotage me ever since then. Okay? But yet he tells the courts that I have interfered on his right to seclusion. I have intrusion upon seclusion. Okay, so number 5, genuine issues of material fact preclude summary judgment on Claims 8 for common law intrusion upon seclusion. The Randazza's 8th claim alleges that defendants' registration of 5 of the domain names containing the entirety or part of their names amounted to a common law intrusion upon seclusion. To recover for the tort of intrusion, a plaintiff must prove that there was an intentional intrusion, physical or otherwise, on his seclusion that would be highly offensive to a reasonable person. Uh-oh. There's the problem, folks. A reasonable person. We just don't have a reasonable person at Randazza Legal Group. I mean, they completely... Did you hear Randazza on NPR? Just like throwing a big hissy fit and crying because I bought a domain name? And the NPR guy, Bob Garfield's like, what was your darkest hour of terror? I mean, I thought I was watching like some sort of a parody on the legal system. I mean, what a joke. But it's not a joke that they've used it to ruin my life, to suppress my speech, to take my blogs, to put it in Forbes, NPR, WIPO, Fraud Files with Tracy Conan, New York Times. It's not a joke when this ruins people's lives. It shuts people up. It gets them lawsuits against them where they have to pay these attorneys to harass them like this. Most people that are sued by these folks give up long before I did. And that's because they have kids, or they have, regular mainstream jobs, or they have, they're threatened with jail or mental institutes or things that they can't stay in the fight as long as I have. And so it's not okay for Mark Randazza to have done what he's done. To use the legal system, to use legal blogs of his friends and buddies to create some sort of what it looks like his target is a criminal, then gives this information to the judges and says, see, there it is, she's a bona fide criminal, right there it is, says so. And his buddies have said it, and Forbes have said it, and all of these are supposed to be credible. Well, this judge is saying no. Forbes is hearsay, the New York Times is hearsay, NPR is hearsay. Okay? Yet you have the judges, the Ninth Circuit judges in my case, that say that it's not, they won't even listen to the issue. They're just like, they call me a criminal? That's okay, right? Because their life is more important than mine. Okay? They can just say whatever they want and take a pot shot at me and just to keep me down, keep me suppressed because I'm exposing corruption. It's not right and it's not legal. Okay, so to recover for the tort of intrusion, a plaintiff must prove that there was an intentional intrusion, physical or otherwise, on his seclusion that would be highly offensive to a reasonable person. To have an insert in seclusion or solitude, to have an interest in seclusion or solitude, which the law will protect, a plaintiff must show that he or she had an actual expectation of seclusion or solitude, and that the expectation was objectively reasonable. Generally, there is a decreased expectation of privacy in the workplace and for individuals who have interjected themselves into the public sphere. You know, like you, Mark Randazza. Media whore. Allegedly, of course. Genuine issues of material fact preclude entry of judgments in plaintiff's favor on this intrusion claim. Plaintiffs Jennifer and Natalia have failed to show by admissible evidence that the mere registration of a domain name would be highly offensive to a reasonable person. There we have it. The Randazzas are unreasonable people. Now we know. Okay, failed to show by admissible evidence that the mere registration of a domain name, which apparently is huge news to Forbes and the New York Times and, you know, Tracy Conan and NPR, it's just huge, massive. We have a porn attorney here who supports someone who writes a guide to being a pedophile, who goes to things with the Free Speech Coalition with, I mean, known pedophiles, registered pedophiles. He defends those that are involved in human trafficking. He's a porn attorney. And these guys are all attacking me for buying a domain name? Alrighty then. Okay. So, I'll read that again. Have failed to show by admissible evidence that the mere registration of a domain name would be highly offensive to a reasonable person. And Mr. Randazza has failed to show that registering the domain names, coupled with the comments contained in the 2 admissible blog posts, would be highly offensive to the reasonable person as a matter of law. Aww, was the unreasonable Mark Randazza offended? I'm so sorry. Mr. Randazza says that the solution to bad speech is more speech. Well, I think Crystal Cox has proved him wrong, because I've given him all kinds of more speech, more speech, more speech. And all he's done is take it to the docket because he's too damn dumb to get higher in the search engines than me, right? So he has to steal my search engine rankings, steal my domain names, accuse me of extortion, publicly defame me in WIPO, defame me in NPR and everywhere else he can, and lie under oath to the Ninth Circuit to make me look even worse. And all this, and he was my attorney. I mean, I don't know that it gets much worse than this, folks. All right, Mr. Randazza has a decreased expectation of privacy in his workplace. By his own characterization, he is an attorney renowned throughout the United States and the world for expertise in First Amendment intellectual property and internet law. He authors a blog about various legal issues, and the blog is an ABA-recognized top blog website. On his blog, he goes to great length to explain why he has the audacity to believe that he is qualified to teach others a thing or two. He has the audacity to believe that he is qualified to teach a thing or two to the others. Sorry, I had to read that again. I think it's kind of funny. Okay, he touts himself as having experience and expertise in all areas of First Amendment and entertainment law matters. I don't think so. He boasts about getting to fight the good fight, protecting all our First Amendment freedoms. Well, not mine. And openly proclaims that he has represented adult entertainment establishments against socially conservative communities. By talking about his experiences and the clients he represents, Mr. Randazza invites commentary on his work as an attorney and criticism from those who oppose the position of his clients. Mr. Randazza may be perceived to have interjected himself into the public sphere by making television and radio guest appearances, giving quotes and interviews in newspapers, magazines, and other publications, appearing at speaking engagements, and having an ABA-recognized top blog website, all as reflected on his resume. Considering his intentional and deliberate professional exposure and interjection into the public sphere and the accompanying decrease in his privacy interest, he has not demonstrated as a matter of law that he had an actual or reasonable expectation that he would not be criticized based on his work as an attorney, or that he would not be thought about unfavorably by people in opposition to his work. So we've called out the truth now. He was butthurt, even though he said Sandra Fluke cannot sue Rush Limbaugh, blah, 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 because she can't sue over being butthurt. But he sued me because he was butthurt. And what was he going to win? He knew I didn't have any money, right? He was my attorney, for crying out loud. He sued me to make a point and to set a precedent so that he can do this to other people who do have money. Okay, yeah, and he says that everybody is allowed to free speech, and even if you don't like the speech. I mean, he defends free speech every which way, but his ego got so out of control with me that he suppressed my free speech rights, sued me, and he went completely opposite of everything that he allegedly stood for. I mean, where does the guy go from this? I'm not really sure. As the Randazzas have failed to establish essential elements of this claim, summary judgment in their favor is simply not available. Well, 5 down. Number 6. Genuine issues of material fact preclude summary judgment on Claim 9 for civil conspiracy. Plaintiff's 9th claim alleges that Bernstein and Cox colluded to register the domain names containing the entirety or part of the Randazzas' names to violate their rights. Yes, that's exactly what I did. I registered the domain names to violate Mr. White Knight, asshole, hypocrite, porn attorney Mark Randazza, who violated my rights and continues to every single day. And who knows how many others he's done the same thing to. Because they didn't squeal as loud as me. Kind of a loud mouth. I don't know if you knew that or not. To state a valid claim for civil conspiracy, a plaintiff must show 1. Defendants by acting in concert intended to accomplish an unlawful objective for the purpose of harming the plaintiff. And number 2, the plaintiff sustained damage as a result. A civil conspiracy claim operates to extend beyond the active wrongdoer liability in tort to actors who have merely assisted, encouraged, or planned the wrongdoer's acts. Genuine issues of material fact also preclude entry of judgment in the Randazzas' favor on this theory. They have not demonstrated by admissible evidence that Cox and Bernstein acted in concert. The only admissible evidence on this point is a blog post purportedly written by Cox. Plaintiff claims that Cox states that Bernstein is her business partner, which is flat out false. He just says what he wants and sometimes even swears to it. However, the pro-offered evidence does not compel that conclusion. The blog post refers in different places to the website markrandazza.me that Bernstein is a co-defendant in this case and that Cox and her business partner have been customers of GoDaddy, Inc. for several years. The blog does not, as plaintiffs suggest, identify or definitely reflect that Elliot Bernstein is the business partner Cox is referring to in the post. And he certainly is not. I've never been in business with Elliot Bernstein. Okay? I've written on his story for 4 years, which is amazing. iViewIt.tv. iViewIt company invented everything to do with video technology, and the inventors never got any rights. It's a $13 trillion technology. And who makes the most money off of it? Probably the porn industry. Defendant Cox is not entitled to summary judgment on her claims either. Cox moved for summary judgment on her original countercomplaint, and that countercomplaint has been stricken, and Cox was given leave to refile an amended countercomplaint, so this is mute and denied. Okay, and then it just goes on to a few other things. So basically, I wanted you folks to know that right to publicity in Nevada law, and to realize that, you know, at least there's one judge out there that does recognize the fact that you can't use hearsay as admissible evidence that's authenticated, okay? If, I guess maybe, and I'm just speculating here, if the New York Times or the Forbes, like if say Kashmir Hill had give a sworn document that she could attest to this is 100% true, and somehow then maybe it could be authenticated. I'm not sure, but it is wrong. It's wrong for the New York Times and Forbes, NPR to be used as evidence in your court case. Now, attorneys like Mark Randazza just use it to create a, the ganging up effect. And they affect the judges. And because they're valued by judges more than people who are pro se, the judges tend to believe them. Like Marco Hernandez, David Amen was constantly trying to tell him that I was extorting him. I never extorted David Amen. I mean, I sent an email, a settlement offer, after I'd been sued for $10 million, and there was 5 emails explaining what it meant. He took a part of one, and the jury convicted me, and this email went around the world, and I've been labeled as an extortionist for years now. And I was never given due process on any of this. And so there's a really good record as to defamation lawsuits and harassment against Forbes, New York Times, Reuters, Randazza Legal Group. There's a whole bunch of people that have wronged me, NPR, and if any attorney wants to represent me in these matters on contingency, then I would love that. My email is crystal@crystalcox.com, and I hope you guys enjoyed this. I know it was really long-winded, but it's important stuff. Randazza versus Cox, you can go to archive.org and you can search Randazza versus Cox and you can get the whole docket, or just search Randazza Legal Group Crystal Cox docket, or you can email me if you need any documents in this case. Study all the documents of this case. Understand the hypocritical actions of Mark Randazza. What I really enjoy doing, kind of one of my hobbies, is getting, where he's fought the other side and taking his own words and using them in motions. Because he's fought both sides, and that's what attorneys do, right? You're hired, so you just pick a side. Well, that's all fine and dandy until you are the plaintiff in one of the cases. Anyway, I'll let you guys know what happens next, but it seems to me that in this ruling, he doesn't have anything to stand on as evidence to move towards a trial with me. Okay, he can't have summary judgment. I am still my own attorney. I've been trying to get the courts to appoint me an attorney because I'm under an enormous amount of stress and I can't take it, and I don't know the laws. I don't know the rules of procedures. I'm a creative writer. I've been doing the best I can because I want to make a stand for others like me. So I don't want to just let it go away because I want to get enough on the docket that helps others in the future. The whole point of putting everything on the docket that I have is to help the whistleblowers, help other citizen journalists, other bloggers, other people that are trying to report on what's going on in the porn industry. Because some of these people are driven to suicide, they're killed, they have heart attacks, they have, they're just put under massive duress, they're sued, they're threatened, their families are threatened, all because they've stood up to these guys in the porn industry. Well, now you have blogs. And blogs are the new media, and they're the only way that people exposing corruption really have to expose it. And now you have an equal right in a higher court to do so. And so we can't have the courts at the same time allowing regular, mainstream journalists to paint you out as a criminal, or lawyers like this to pile up evidence of their buddies and their different media and lawyer connections to make it look like you're a criminal. There's important, dark, sick issues in the porn industry that people like Desi Fox and Monica Foster are exposing, and it's very, very important. They're like 2 very prominent investigative bloggers in that industry that are exposing corruption. And the human trafficking, the organized crime, the pedophiles, the free speech coalition, what goes on in the porn industry needs to be exposed. And there's a lot of layers to it. I've written a lot about it. I've learned a lot about it, and I was going to go into some of the stories, but I think that's enough for today. I hope you all have a great day, and God bless you all.